must say this is not a topic that I usually address in my capacity as ambassador. I was at another conference this week in Warsaw, which was with some Russian colleagues, and we were discussing the current security issues that Europe currently faces, and that was also a below the radar conference just like this one, but nevertheless I'm very happy to be able to share some thoughts with you, and thanks very much once again for inviting me. Of course, inevitably, representing the Council, what I say will probably be a lot more apolitical than the last intervention that we just heard. But I think it's very useful to have this discussion with members of the European Parliament, with the members of civic society. I know that there's nobody from the Commission here today, but nevertheless, and there's also, of course, nobody from the Hungarian government. But I think everybody knows what the position of the Hungarian government is in any event. So we're essentially addressing the question of what the European Union can do if a member state, as you term it, regularly and systematically breaches the European norms and regulations. And I've been asked specifically to speak about the rule of law mechanism in the Council of the European Union. And I want to just mention three brief points as my contribution. First of all, I want to reiterate the importance of these issues. Secondly, I'll just give ourselves, I don't know if it was already touched upon in the opening session, unfortunately I couldn't be there, some brief reminders about the nuclear option, Article 7 of the Treaty on the European Union. And then I'll just finish off with some thoughts on how the Presidency of the Council is dealing with the rule of law mechanism at the moment from a Latvian perspective. So, of course, the rule of law is the founding principle of any democratic society. And of course, it's also one of the founding principles and the core values of the European Union itself, as Mr. Kavada pointed out, an essential pillar of the European Union. And this is probably the crux of why it's crucial to uphold the rule of law principles. Because, of course, by failing to uphold those principles, primarily the European Union can then become vulnerable to accusations of double standards. And as a foreign policy practitioner, I fully appreciate the implications that this has on third countries. And we know very much that the rule of law issue has become a vital instrument used concerning those countries that want to join the European Union. Apart from being ambassador to Hungary, I also am ambassador to Montenegro for Latvia, and so I have a very clear view of how rule of law questions are at the front and centre of the negotiating process with Montenegro. The emphasis on chapters 23 and 24 and clear progress in areas such as fight against organised crime and corruption, freedom of the press and other rule of law issues, these are directly linked to the speed of negotiations. And as Morten pointed out this morning, the Commission indeed also in the negotiating process uses very much the Council of Europe and the Venice Commission, which shows how the interlinking of the institutions also plays into the accession process for accession to the European Union. I could also add that vis-à-vis Montenegro's aspirations to join NATO, there is a lot of interlinking in Brussels between the Commission, discussions with their NATO counterparts, specifically on how Montenegro is performing on chapters 23 and 24 and rule of law related issues. So I'm also aware of the criticism that the requirements that we seek from accession countries seem not necessarily to be applied so rigorously to member states themselves. And this, of course, is nothing particularly new. At the same time, in trying to increase the role of the European Union as a global actor, quite clearly we need to lead by example. Amongst the top foreign policy issues under Latvia's presidency is the question of our relations with our Eastern partners. as we know, there are 6: Ukraine, Georgia, Moldova, Armenia, Azerbaijan, and Belarus. And some of these countries also seek a European perspective and certainly closer ties with the European Union. So the importance and magnetism of European values, I think, was well illustrated by the people of Ukraine on the Maidan Square in Kiev last year. Whilst waving European Union flags, they rejected the corruption and disrespect for the rule of law that their ruling elites had previously offered to them. And this demonstration in favour of the rule of law may well have been one of the factors that influenced Russia's President Putin in starting aggressive actions against Ukraine and totally rejecting the law-based international system which had prevailed following the end of World War II. And as we know, because of that rejection of the international law-based system and the rule of law system, we now have a totally new security situation in Europe. As Michael Ignatieff recently pointed out during a very inspiring lecture in Budapest about the very topic of illiberal democracy, unfortunately, rather than the rule of law, Russia is an example of a country run on the principle of rule by law. And I particularly like the quote which he used vis-a-vis Russia's leadership. He said, "For my friends, everything; for my enemies, the law." Of course, the preferable version of that should be, "For my friends, nothing; for everybody, the law." So, as we see, the rule of law principle is important because not only is it part of the foundation of the European Union, but by making sure that we stick to the principles ourselves, we can also improve our own credentials as a global foreign policy actor. So let me now just move on to the question of Article 7 of the Treaty on European Union, because I think it's important to just remind ourselves what the current procedures for ensuring respect for the rule of law and fundamental values are, as laid out in the treaty. And here, of course, we're looking specifically at the role of the Council, which provides 3 specific procedural stages. So first of all, we need a 4/5 majority of Member States agreeing to act on a proposal, indeed a reasoned proposal, as it's referred to, for inviting the Council to take steps made by the European Parliament, or by 1/3 of the Member States, or by the Commission. Furthermore, it is in any event necessary to obtain the consent of the European Parliament. The basis for a proposal is described as being, and I quote, "a clear risk of a serious breach by a Member State of the values" in Article 2 of the treaty. So that was the first stage. The second stage involves the Council, and here the Council has to act by unanimity on a proposal by 1/3 of Member States or by the Commission, and again after obtaining the consent of the European Parliament. The Council may determine, and I quote, "the existence of a serious and persistent breach of values" after inviting the Member State to submit its observations. So we have the dialogue with the Member State being involved there. And I want to emphasise the words serious and persistent only because, of course, our session here refers instead to regular and systematic breaches, and not of values, but norms and regulations. So, of course, our discussion at the moment is slightly going outside of the Treaty on the European Union specifications. And the third stage of the nuclear option process involves a qualified majority decision of the Council, which may be taken to suspend certain of the rights of the Member State in question. And that's, of course, the way in which the nuclear option operates, by the suspension of voting rights of a Member State. I also want to take the opportunity to mention the letter of the 4 foreign ministers of Denmark, Finland Germany and the Netherlands, because I think that this did make an important contribution to the debate, prompted the Commission to propose a new framework for the rule of law, which has been looked at, but as we know, is perceived as being legally unworkable. And so finally, let me just give you some insight onto where we are vis-à-vis the Presidency and Council perspective. The Presidency role in dealing with the rule of law, before discussing that, I think it's really important to remember that the construction of the European Union is such that institutional interaction is crucial. I was also, for a short time, a member of the Latvian Parliament, and I very much appreciate the role that Parliament plays within the democratic system of checks and balances. And I think that the European Parliament's contribution to the debate and suggestions on how the Union can better address problems surrounding the rule of law are in fact invaluable. And the role of the European Parliament has also been referred to, as I mentioned, in the procedures relating to Article 7 of the treaty. Concerning Latvia's presidency, our work programme is essentially based on the trio of presidencies that was agreed, because as you know, we took over from Italy on the 1st of January this year. Latvia took over the presidency, and Luxembourg will take over from Latvia on the 1st of July. So we're essentially sandwiched between two founding member states of the European Union with a lot more experience of conducting presidencies than we have. But in preparation for the start of the trio presidencies, there was an agreement in June of last year on the joint 18-month work programme, which the Council subsequently endorsed at a General Affairs Council meeting. And this refers in particular to dealing with, amongst other things, issues relating to governance, the rule of law, and human rights. And I think what's important, if we just look procedurally at what's happened, is that this was again picked up and dealt with by the General Affairs Council meeting on the 16th of December last year under the Italian presidency. And the conclusions of that council meeting essentially set out what the Council is doing to try to strengthen respect for the rule of law by member states. And based on these conclusions, Latvia fully acknowledges that the Council's ability to act has to be within existing treaties. Latvia also fully accepts that the approach to be taken with regard to dialogue amongst member states has to be based on equal treatment, an evidence-based approach, and principles of objectivity. And of course, it's necessary to have consensus about the themes that can be taken on board within the particular dialogue. So it's very clear that the 28 member states agreed on the 16th of December how to move ahead with the rule of law mechanism in the Council. And it does seem that the dialogue will continue during Luxembourg's presidency during the next half of this year. There was mention of the one yearly review, and it may be that this will be conducted during the presidency of the Luxembourg. But in any event, the good news is that one of the countries that signed, whose foreign minister signed the letter of the four foreign ministers, the Netherlands, will be taking over and will certainly have agreed a new trio presidency, and there will be then an indication of how we move further down the road on these very important issues. And I'll just conclude by perhaps repeating Morten's conclusion, because I thought that was quite an interesting one, which he introduced his contribution by saying that he said that we don't need new institutions and procedures, but we need to use them better. Thanks very much.